goal of the Americans with Disabilities Act, or A.D.A. for short, is to give those with disabilities the same opportunity for employment and benefits as everyone else. Title I of the Americans with Disabilities Act of 1990 prohibits private employers, state and local governments, employment agencies, and labor unions from discriminating against qualified individuals with disabilities in job application procedures, hiring and firing, advancement, compensation, job training, and other terms, conditions, and privileges of employment. An individual with a disability is a person who has a record of or is regarded as having a physical or mental impairment that substantially limits one or more major life activities. A qualified employee or applicant with a disability is an individual who, with or without reasonable accommodation, can perform the essential functions of the job in question. Reasonable accommodations are adjustments or modifications provided by an employer to enable equal employment opportunities for people with disabilities. This may include, but is not limited to, rearranging facilities or modifying equipment, modifying examinations, training materials and policies, and providing qualified readers or interpreters. Remember, accommodations vary depending upon the needs of the individual applicant or employee. Not all people with disabilities or people with the same disability will require the same accommodation. An employer is required to make reasonable accommodation to the known disabled qualified applicant or employee if it would not impose an undue hardship on the operation of the employer's business. Undue hardship is defined as an action requiring significant difficulty or expense when considered in light of factors such as an employer's size, financial resources, and the nature and structure of its operation. Additionally, the A.D.A.'s non-discrimination standards apply to federal sector employees under the Section 501 of the Rehabilitation Act, as amended, and its implementing rules. Title I of the A.D.A. also covers medical examinations and injuries with regard to a disability and employers' responsibilities in certain drug and alcohol abuse situations. For instance, employers may ask applicants about their ability to perform specific job functions, but not about the existence, nature, or severity of a disability. A job offer may be conditioned on the results of a medical examination, but only if the examination is required for all entering employees in similar jobs. With limited exceptions, any medical information employers learn about an applicant or employee must be kept confidential. Information can be confidential even if it contains no medical diagnosis or treatment course, and even if it is not generated by a healthcare professional. An employee's request for reasonable accommodation would be considered medical information and is subject to the A.D.A.'s confidentiality requirements. However, employees and applicants currently engaging in the illegal use of drugs are not covered by the A.D.A. when an employer acts on the basis of such use. Employers may hold illegal drug users and alcoholics to the same performance standards as other employees. Finally, it is also unlawful to retaliate against an individual for opposing employment practices that discriminate based on disability or for filing a discrimination charge, testifying, participating in any way within an investigation, proceeding, or litigation under the A.D.A.